COP26 conference meant to be held in Glasgow in November. From there, we'll have committee business. I don't know what is committee business. And then we'll consider the minutes, consider and adopt the minutes of the 31st of August 2021. And then we will deliberate. I think we will have to club item number 3 and item number 4. Committee deliberations on the multi-party delegation to UNFCCC, and then we'll adjourn the meeting. Can I get the mover of the adoption of the agenda as presented?
Chairperson, I move. Bryant.
Thank you very much, Honorable Bryant. Can we get the seconder?
Chair, I've raised my hand. I move for the to second the adoption of the agenda, but I have a concern. I saw before the meeting, just now the meeting before it started, there was a logo that was flag on our screen, and I think that is not correct. This is a meeting of the portfolio committee, not an organizational meeting. Thank you.
Sorry, Chair, it's mine. I logged in on the wrong account. I'm going to log out and come back in on the other account. I apologize profusely. I didn't notice.
That apology is accepted. To err is human, Honorable Phillips. Colleagues, let's then move. Can we get apologies, Chileka?
It's the chairperson's apology, Mr. Mudisa, and the Honorable Olomisa. Those are the only 2 that I've received.
All right, from honorable members, can I check if there are other apologies that have been deposited?
Chairperson, good morning. It's Singh here, and good morning to the Minister and the colleagues. Yeah, to err is human, to forgive is divine. Remember that. And you are divine, you have forgiven. Chair, I'd like to leave at 12:30 because I have a Sub-Saharan conference on climate change starting soon after. Thank you.
That apology is noted, Honorable Singh. Further apologies?
Chair.
Honorable Gancho.
Good morning, Chairperson. Greetings, colleagues. Chair, I have a problem with network. I just wanted to note that so that if I disappear, you know that I have a problem with connection.
It is noted, Honorable Gancho. Please don't disappear.
Okay, Chair. It won't be out of my own doing. Okay, Chair. Thank you.
Further apologies, colleagues.
Chair.
Minister.
Good morning, Chair. May I table the apology of our Deputy Minister? She has other matters she must attend to this morning, and I will be leading the delegation. Thank you.
Wonderful. It is noted, Minister. Further apologies, colleagues. All right. Now we have adopted the agenda and noted all these apologies. Can I then take this opportunity to welcome you officially, Honorable Minister? You will tell us who is leading, who is in your team that you are leading from the department. Can I hand over to you to welcome us?
Thank you very much, Honourable Chairperson, and greetings to all the honourable members.
Recording in progress.
Chairperson, our Director General, Ms. Nomfundo Chabalala, is with us, and we have a number of Deputy Director Generals and other colleagues with us. I think that as we go along, I will be introducing colleagues. I think the first item, it's going to be presented by Ms. Linda Garlip, but she is accompanied by the Deputy Director General, Ms. Vanessa Benderman. And the presentation on the FRAP will be presented by DDG Sue Middleton. I'm just looking to see who else is with us, but she will, I'm sure she will indicate who from her team is with her. Thank you very much, Honorable Chairperson. With your permission, my team will proceed with the presentations.
Thank you very much, Minister. Should I hand over to the DG? DG?
Thank you, Chair. Good morning, Chair. Good morning to the honorable members. I think I will immediately hand over to the team that is presenting, Chair. Thank you very much.
Good morning, Honourable Chair. I'm Linda Garlip. I'm the Chief Director for Law Reform and Policy Coordination, and I will do the presentation on the update of the legislation amendments. Okay, the National Environmental, I will start with the National Environmental Management Laws Amendment Bill, which is currently in the Select Committee, and then the National Forests Amendment Bill, that is also in the Select Committee at the moment, the Climate Change Bill, that will be introduced in Parliament soon, and the National Veld and Forest Fire Amendment Bill that will also be introduced in Parliament soon, the Aquaculture Development Bill, and the National Environmental Management Biodiversity Bill. The National Environmental Laws Amendment Bill amends the National Environmental Management Act, as well as a number of specific environmental management acts, which deals with specific aspects of the environment, national air quality management, biodiversity, coastal matters, protected areas, and waste management. The National Environmental Laws Amendment Bill is the umbrella legislation in the specific environmental management acts are then under these this umbrella legislation. So the
recording stopped.
The National Environmental Management Laws Amendment Bill amend the National Environmental Management Act, the Air Quality Act, the Biodiversity Act, the Integrated Coastal Management Act, the Protected Areas Act, and the Waste Management Act, as well as the National Environmental Management Act Amendment Act of 2008. Basically, what the bill does, it addresses implementation challenges, and the bill was introduced in Parliament in May 2017. The D version of the bill was passed by the National Assembly in November 2018. The bill was presented in 2020 to the joint meeting of the Select Committee on Land Reform, Environment, Mineral Resources and Energy. The bill was consulted on by the Select Committee and is currently still considering the voting mandates received from the provincial legislature, but it's clear that there will be amendments to the bill. The bill, the process of the meeting dates change, so they will consider today, this afternoon, the voting mandates of Gauteng, and thereafter the E-list will be drafted and considered by the Select Committee. And once the bill is passed by the NCOP, the bill will be referred to the National Assembly to be considered. The National Assembly will then either pass the bill or
recording in progress.
Refer the bill for mediation. The National Forest Amendment Bill. The purpose of the National Forest Amendment Bill, or the National Forest Act is to promote sustainable management and development of forests and to provide for the protection of certain forests and trees. In summary, the objects of the Amendment Bill are to provide clear definition of terms, to increase the promotion and enforcement of sustainable forest management, to increase measures to control and remedy deforestation, to provide for appeal procedures, to promote equity by inclusion of participation into the National Forest Advisory Council, and to strengthen the council by including vulnerable and previously disadvantaged groups, especially women and youth. Next slide, please. The Select Committee consulted on the bill. The Select Committee considered and voted on the negotiating mandates received from the provincial legislature on 1 June 2021 and 8 June 2021. The C list containing the proposed amendments of the bill has already been prepared. That will be discussed this afternoon, and not the meeting of the 31st of August 2021 was cancelled. Once adopted, the D bill will be finalized and adopted by the Select Committee and submitted to the National Council of Provinces to be passed. Once the bill is passed by the NCOP, the bill will be referred to the National Assembly to be considered, and the National Assembly will either pass the bill or refer the bill to mediation. Next slide, please. The climate change bill, the bill seeks to provide for an effective climate change response for the country and a long-term just transition to climate resilient and low carbon economy and society in the context of sustainable development. The national climate change response include mitigation and adaptation actions, which represents the public fair contribution to the global climate change response. The bill is currently being taken through the cabinet processes. It will be discussed tomorrow at a cabinet committee and on the 15th at cabinet. And thereafter, if cabinet approves that, it will be tabled in parliament. Next. Okay, the National Veld and Forest Fire Amendment Bill. The bill seeks to amend the National Veld and Forest Fire Act 1998 as to amend and insert certain definitions, provide for the facilitation of the formation of fire protection association by a municipality or traditional council, compel municipalities, state-owned enterprises, public enterprises, or other organs of state which own a land to join the fire protection association. It also extends the powers of entry, search, seizure, and arrest to peace officers and traditional leaders in terms of the bill, and it also amends the title of the act to the National Veld Fire Act, and the bill will go through the cabinet system in September. It will be, if everything goes well, it will be considered by the cabinet committee on the 29th and by the full cabinet on the 22nd by the cabinet committee and the 29th by the full cabinet. The National Environmental Management Biodiversity Bill. The National Environmental Management Biodiversity Bill was commissioned to address the current complex, restrictive and inflexible regulatory system of the current Act, leading to the concern of over-regulation and excessive administrative requirements. The Biodiversity Bill provides for flexible, empowering provisions for conservation, management and compliance. The current bill repeals the Act, but does not change the current national policy position or conservation principle, but enhances and improves and streamlines it. And that is a challenge at the moment because we foresee that some of the underlying policy principles will need to change. The bill was ready to be introduced to Cabinet for approval for publication for public comment, but was withheld pending the report of the high-level panel of experts for the review of policies, legislation, and practices on matters of elephant, lion, leopard, and rhinoceros management, breeding, hunting, trade, and handling, and the finalization of the white paper on conservation and sustainable use of biodiversity. Now, these documents will influence some of the underlying policy positions in the bill, but it still needs to go through a public consultation process, and that is the reason why the bill has been held back. The bill will probably only be ready for tabling in 2023. The Aquaculture Bill, the bill seeks to create a conducive and enabling legislative environment for sustainable aquaculture development that is globally competitive, coordinate the sustainable development of the aquaculture sector, both marine and freshwater subsectors throughout the country, address the legislative gaps that are a hindrance to the development of the sector. The status of the bill temporarily withdrawn from the Parliament to allow for further consultation with industry stakeholders. And there was a task team established and the first round of stakeholder consultation did take place, but currently that is now currently the comments received are currently internally considered, and then there will be another round of industry consultation to resume once these internal consultations are finalized, and the department will possibly undertake the consultations again due to possible substantial amendments, but we are not sure. The bill will be reintroduced in Parliament during 2022-2023 financial year. Amendments to the Marine Living Resources Act due to the fishing rights allocation process receiving priority this year. The department will commence with the amendments of the Marine Living Resources Act in 2022. The department will initiate the process with a concept document. Thereafter, the bill will be drafted and taken through the processes. It's foreseen that the bill will be tabled late in 2023 or early 2024. Thank you, Honourable Chair.
Thank you very much. Honorable members, that is the presentation of legislative amendments. May I invite you to engage the presentation and seek clarity where necessary. The hand of Honorable Singh is up. Honorable Singh. The hand of Honorable Weber is up. Then the hand of Honorable Dave Bryant is up. In that order, Honorable Singh, Weber, and Bryant.
Thank you very much, Chairperson, and thank you for the presentation. Honorable Chairperson, I would take it that this is merely a briefing to us as a committee to update us on the legislation that's on the table, and that's going to be on our table in future after it goes through cabinet processes, so that the public and anybody else can comment. So all I can say for now is I'm not going to engage any of the contents of the legislation, but for me, note it as legislation to come before our committee for further consideration. And I don't know if I'm right or wrong in that aspect. Thank you, Chair.
Thank you, Honorable Singh. Honorable Weber.
Thank you, Chair. I also agree with Mr. Singh. It is concerning that some of the, well, most of these does not come back to our committee for perusal. I do understand that most of them must have been done in the 5th Parliament. I would like to know, especially with the 3 bills, the first 3 bills, there's no timelines, and already they say that 24 August this would have been done, but they're busy with it today, which is already the 7th of September. So sticking to the timeline is already a concern to me, and it is a very long process to develop the laws and amendments to these bills. But I do believe we somewhere must have some kind of basic timeline where to say it goes to the selection committee that have been busy for it for a while, probably 2 years, and then it will go to, can we maybe have some kind of indication what the timeline is for these bills to be finished by the NCOP and for the bills to go to Parliament? By what time will it go to Parliament? To just have clarity there, because it's kind of remain in the dark. Okay, but I want to thank you for this, because now we also know what we are busy with, what is happening with all the bills that we're busy with. The second thing I would like to know, you speak about public participation will still happen with the Biodiversity Bill, for instance, and then you speak about aquaculture, that consultations, the second round of consultations will take place. So my question to you, is the consultations with the Aquaculture Bill actually the public participation, or will public participation happen after these consultations, because there's no mention of public participation? So my question there, is the consultations the same as public participation? Thank you very much. Thank you, Chair.
Honorable Bryant.
Thanks, Chairperson. Chairperson, just to follow on from Honorable Weber, I'd be interested to know how the change in our current parliamentary schedule, with us rising on the 13th, is going to impact some of these possible slightly vague timeframes that have been presented. And secondly, whether there is or there will be ongoing engagement with all of the stakeholders involved in the drafting of this legislation. We do tend to find that at the last minute, we get contacted by stakeholders, particularly in the various communities and stakeholders in business, etc., and the other non-governmental organizations, saying that they haven't been properly consulted. So I just want to, make sure that when these pieces of legislation do eventually get to the point that they are formally presented to us, all of those engagements have taken place or are already effectively underway. Thank you.
Thank you, Honorable Bryant. Honorable Mbata.
Chair, morning, everyone. Thanks, Department, for the presentation. I have a concern on page 9 under the National Environmental Management Biodiversity, where they talk of the high level panel of experts that has to review the legislation. And the things that they are talking about, the issues, the matters that they are talking about are of urgent attention. When they talk about the elephant, the lion, the leopard, the rhinoceros management, breeding, hunting, and they say it will be tabled, it will be ready in 2023. Yet we have a crisis on lion breeding. And I think we're still waiting for the high level panel to give us a feedback as the PC on the lion breeding. To me, it's a serious concern, and the time frame is very long. It's very long. I don't know when they develop their policies or the bills, what is their time frame and what do they consider continuously when they are busy with those the bills. My worry is on that, because it's a crisis in South Africa. Thank you.
Thank you very much, Honorable Mbata. Minister.
Thank you very much, Chairperson, and thank you to the honourable members for the questions. Let me just make a couple of points and then I will hand over to Ms. Garlip to deal with the detail. I think that colleagues would obviously understand that once a bill leaves the executive arm of government and enters into the legislative arm of government, we are merely in a support capacity. We don't determine timeframes, we don't determine approaches and so on. So I would want to suggest, Honourable Modise, that it might be appropriate for the Portfolio Committee to have a discussion on the amendment legislation with the Standing Committee in the NCOP. It's very inappropriate for me as being in the executive arm of government to start saying, hurry up. And I think that issues also, what one needs to understand is that there's always two sets of consultation that take place around any legislation. The first set of consultation is when the executive arm of government decides to put out a bill. It must be put out in a draft form for public comment. Those comments must then be factored in. It must then go back to cabinet. And from there, it will come to the legislative arm of government. The legislative arm of government will run its own public consultation process. So the consultation run by the executive is in the executive domain, but the legislature will run its own public consultation. So if we go to the Aquaculture Bill, that bill, when I became the minister, the industry came to me and they said to me, there are provisions in this bill that we regard as difficult and onerous. And we intend to contest this bill in the legal domain. And I said to them, let's not do that. Let's sit down and let's work out what are the complexities you see, and let's see how we can find each other around these complexities. So that process is happening in the executive domain. When the executive is satisfied, because that bill will have to go back to cabinet once that process is finished. Once the executive is satisfied that we've done what we can do, we will give the bill to you and you will run your own consultation process. And obviously on the basis of that consultation process, you will suggest amendments to the bill. And then we will have to decide whether we accept those amendments or not. So I just think it's important that we understand that in these processes, we have different powers and different responsibilities. And whatever we do in the executive arm of government, it doesn't undermine the power that you have to engage in public consultation. The reason, Honourable Bryant, that these pieces of legislation have to come back to the National Assembly after the National Council of Provinces is that you would then need to consider whether those amendments are in keeping with the original mandate you would have had from your own public consultation process. And then you will decide what you do. Because the National Assembly, in a sense, has the last say. Honourable Mbata, I think that one fully recognizes the important points you're making with regard to the recommendations of the high-level panel. With regard to the specific recommendations on the 4 iconic species, you would be aware that we have put out a policy paper for public consultation. There has been a lot of public interest in that policy document, and I was approached by members of the public to ask me to extend the public consultation on that document beyond a month, from 30 days to 60 days. which I thought, in view of the level of public interest, that was a reasonable process. Once we have considered all the submissions, we will obviously then be needing to make policy decisions with regard to the 4 iconic species. But there are broader recommendations in the high-level panel recommendations. You'll recall there's 68 recommendations there. There are broader recommendations that cut across the biodiversity and conservation sector and are more wide-ranging than just those 4 iconic species. Now, I think it's what was the view when we looked into that is that in the end, you would need to look at, there was a draft white paper, and I would really urge honorable members to look at it. There was a draft white paper on biodiversity and conservation in 1997. That white paper was never finalized. So there isn't a white paper on biodiversity and conservation. We believe that that's necessary. And obviously, once you do have that white paper, because obviously there are complicated issues on the relationship between sustainable, exactly what do you mean by sustainable use? I think that's a very complicated issue. And it cuts across the sector as a whole. So in that regard, I think that there would be a need for more policy work that could then result in us looking at the draft white paper and updating it. Once that has been adopted by Parliament, then obviously one would need to bring the legislation in line with that white paper. So I think that what we're saying is there's a short-term process, and that is on some of the immediate issues. And then there's a longer-term process on some of the more complex policy processes, which we think require further consideration by the public, by the National Assembly, by the NCRP. I hope that helps to clear up some of the complexities. Let me hand over to Linda to deal with some of the nitty-gritties.
Thank you, Honourable Chair and Honourable Members and Minister. Most of the questions have been answered by the Minister sufficiently. I will just answer how Parliament programme will possibly be affected by the tabling of the Climate Change Bill and National Veld and Forest Fire Amendment Bill. The Climate Change Bill, once it's approved, for instance, approved, and we can't predict what Cabinet will do, but if Cabinet, say for instance, approve it on the 15th of September, then thereafter, for tabling in Parliament, thereafter we still need to publish it in terms of the rules in the Gazette. We have to submit it to the State Law Advisor to be certified and translated. And then it's actually tabled and it's sent to the tagging committee. So there's a while that there will still be a while before it actually reached the portfolio committee. The same with the Forest, Veld and Fire Amendment Bill. The same, it will be in, it is foreseen that it will be in the Cabinet Committee on the 22nd, and then on the 29th, it may be approved. We can't predict what Cabinet will do, but thereafter we still have to run a process before actual tabling, and after tabling it needs to go still to the tagging committee. Then in terms of the processes of the National Forest Amendment Bill, that is fairly at the end. They will discuss this afternoon the C list, and depending on how well that goes, it can be fairly soon be go to the NCOP to be passed. But the National Environmental Laws Amendment Bill, we are not at that stage yet, and it might still take a while. And those processes, as the Minister indicated, are not in our control. On the NEMPA Bill, the National Environmental Management Biodiversity Bill, we haven't consulted yet with the public. So this will be the first time that it goes through Cabinet, and then we consult with the public, and it needs to go back all the way through all the processes again, Cabinet processes again, before it can be tabled in Parliament. And that can take quite a while, but we haven't before consulted on the NEMPA Bill. In terms of the Aquaculture Bill was previously consulted with the public. It was actually tabled in Parliament. It was withdrew for consultation purposes. And now if we do not do a lot of amendments, it can actually be tabled in Parliament directly after Cabinet, but it will depend on the number of amendments required, whether we will still to publish it again for public comment. But that is a decision that haven't been taken, because it will be very much dependent on the number of amendments that we are going to do. And that is all from my side. I think the rest of the questions had been answered by the Minister. Thank you very much, Honourable Chair.
Honourable Bryant, I see your hand is still up, and the hand of Honourable Mbata, in that order.
Sorry, Chair, it's an old hand. I'm going to put it down.
All right, Honourable Mbata.
Thank you, Chair. I think what I will request from the department via the Minister and the Deputy Minister is that can we be informed on the participation or consultation with the community, because in most cases, the most affected communities don't get the chance to participate in those bills. And if we, as the Parliament, assist them to get those amendments for them to participate, it will be much better. And the other thing that I'm worried about, in our Black communities, we have those who can't read and write, and the so-called bills, they affect them directly. But in most cases, those bills are in favor for those who can read and write. That must be taken into consideration so that we afford all our communities time to participate. I'm talking from experience, because we find that when communities start to complain, they say, but there was a public participation or consultation, and hence this issue was approved. You didn't participate. So we need to protect our communities. Thank you, Chair.
Thank you, Honourable Mbata. I had noted, based on the previous set of questions, there was a question by Honourable Bryant, because Parliament will be rising, I think, on the 13th, and he asked if won't that affect the timeframes that the department has set itself up for. Does it affect the timeframes that are being presented here? I'm not too sure if that question has been responded to. The question of consultation, I think it cannot be overemphasized. This is the last point also that has just been made by Honourable Mbata. And the timelines. Honourable Weber, I think, spoke about the timelines of the appearance of these legislations, pieces of legislations in Parliament, although the Minister has explained the processes of how it has to be processed from one area to the other. Just in closing, can we just attempt to respond to those few areas, and then we move on? Minister?
Honorable Modise, I think that I'm suggesting that perhaps that question of the implications of the timeframes belongs in the domain of the portfolio committee, because all we can do is put the bills into the relevant assemblies, but how they are processed and how the implications of the schedule of Parliament, it's really in Parliament's domain. So if honourable members of the committee are concerned that they are of the opinion that these processes must be fast-tracked, then we would appeal to you to engage with the relevant officers in the two assemblies, because this is really outside of our domain. That is my suggestion. And I think that the point that Honourable Mbata has raised about how the portfolio committee creates accessibility for communities who would be interested in legislation and policy-making processes that might not have access to Zoom and to formal meeting venues in the Western Cape or in Gauteng. I think that I'm sure the National Assembly has learned very interesting lessons from the very participatory process that was run around the land issue. And I would want to suggest honourable members might want to interface with that process and see whether there is something there that they would find useful and relevant to encourage public participation amongst a broader groupings of society. We went to considerable lengths when we were doing the high-level panel, despite the lockdown. We went to considerable lengths to meet with communities, or we sent the high-level panel to go and meet with communities physically on the borders of our national parks, because I think that we fully appreciated the point that Honourable Mbata is making, that very often the recipients of policy are those who are least empowered to actually impact upon it. So I think that we did special processes at that time to enable, I think it was about 13 communities to participate in the matters before the high-level panel, precisely because we understood that if everything else was being run virtually, that could not be run. So I think we fully support you on this view, Honourable Mbata, and I'm sure the legislative arm of government has got interesting experiences which could be reflected on by yourselves. I hope I've dealt with the issues, Honourable Modise.
Thank you very much, Minister. Chileka, it is a decision of this committee that there must be extensive consultation with the Standing Committee of the National Council of Provinces, so that before we put a blame squarely on the doormat of the department, we must have done our part as a portfolio committee. So can we engage on this piece of legislation, check how far they are, and when are they coming to be presented to both houses of parliament, and that be a decision of this committee that in the next meeting we'll get a report on how far they are, particularly from the NCOP and those that are in the NA. All right. Thank you very much, honorable members. Can we move to the next item? Who is flagging the agenda?
It's the update, Honourable Chair, on the FRAP process. Can I invite DDG Sue Middleton to do the presentation? Thank you very much.
Good morning, Honourable Chair, Honourable members, Minister, and colleagues. Thank you for the opportunity. I will take you through the presentation, but just at the outset, to indicate that on the 1st of September, so last week, Wednesday, Cabinet noted and endorsed the timeframes that we are now going to present to you for the remaining steps of the FRAP allocation process. If we can move to, so slide 2 is just a list of acronyms indicated in the presentation. I won't take you through that. Slide 3 is an overview of the presentation. So we're going to look at background to the FRAP 21 process, the progress report that we've made so far in terms of implementation, an update on the milestones, the steps to come with timeframes, and then lastly, just FRAP appointments to augment our capacity. So if we can move to slide 4, in terms of the background, sorry, can you go back? Thank you. We last presented a progress report on FRAP to the Portfolio Committee on the 10th of November 2020. So just to recap, since the 10th of December, the department has set up systems to ensure that the project is delivered within the set timeframes of 31 December 2021. To recap, there are 12 sectors where rights expired in December 2020, and those sectors have been fishing on an exemption, and rights will now expire finally on the 31st of December 2021. And those sectors are KwaZulu-Natal prawn trawl, demersal shark, tuna pole line, traditional lionfish, squid, small pelagic, which includes pilchards and anchovies, hake deep sea trawl, hake longline, and South Coast rock lobster, white mussels, oysters, and hake handline. The 3 fisheries that are indicated in red, white mussels, oysters, and hake handline, a decision has been taken to declassify those as they no longer will be classified as commercial fisheries. They will go to small scale 100%. So in essence, we will be allocating 9 commercial sectors in December 2021. If we can go to the next slide, please. So this slide indicates that internally at administrative process, we've identified 14 distinct phases in any rights allocation process. The first 7 on the left-hand side in the table have been achieved, and the remaining 7 on the right-hand side of the table are still to come. Next slide, please. So this is some of the details of what we have achieved so far in terms of step 1, which is the appointment of delegated authorities. In the FRAP 2021 process, the Minister has taken a decision to appoint multiple delegated authorities and not just one, which was the case in FRAP 15 and FRAP 13. And we believe that the appointment of multiple delegated authorities will assist in minimizing the possible risk of manipulation and impropriety. Next slide. Step 2, which is the appointment of project teams. A number of multidisciplinary task teams have been established to drive and support the various phases in the FRAP process, including the internal review of policies and application forms, the finalization of the socioeconomic impact assessments, and the provision of technical support and advice to the delegated authorities when the allocations and decision-making phases commence. Next slide. Step 3 was the gazetting of the commencement of the allocation process, and a government gazette notice was published on the 26th of June 2020, announcing that the FRAP process had commenced. Next slide. Step 4 was the resource split and the commencement of the allocation of fishing rights. So apportionment splits have been finalized in the squid sector, pending an appeal that has been lodged. And we, as already mentioned, we are finalizing the apportionment splits in the remaining sectors. A decision has also been already been taken to declassify white mussels, oysters, and hake handline. And then we are finalizing apportionment splits in traditional lionfish. We have also reviewed the general policy and the 9 sector specific policies, the fish processing establishment policy, the application forms, and the applicable fees. Phase 1 of the socioeconomic impact assessments have been taken internally. The report has been submitted to the presidency. Feedback has been received and they've been resubmitted to the presidency for certification, which we are expecting this week. And we've now concluded the internal consultation process on the review of all the applicable policies. Those will be approved in the coming week and published for public comment. Next slide, please. In terms of the appointment of service providers to assist the department and also to ensure independence and transparency, we have appointed 4 key service providers, namely the FRAP implementer, the FRAP process observer, the FRAP tip-off line, and the FRAP information technology and communication service provider. In addition, the department has appointed senior and junior counsels through the Office of the State Attorney to provide legal advice to the FRAP teams and the 8 delegated authorities as and when the need arises. And an additional service provider is in the process of being appointed to conduct forensic audit services for those who were successful in the FRAP 15 process and to provide ad hoc forensic investigations to the FRAP 21 process. Step 6, the appointment of members of the Consultative Advisory Forum, CAF. This is slightly broader than just FRAP because their term of office will extend beyond the FRAP 21 process, but the appointment is underway. The Minister has appointed 6 multidisciplinary members to the CAF, comprising 2 international fisheries experts, and provision has also been made for the participation of 4 representatives of the small-scale fishing sector, representing each of the 4 coastal provinces. Their appointment for the representatives of the small-scale sector will be done at a later point. Next step. Next slide, sorry. Step 7, internal review of the policies, application forms, fees, including conducting the socioeconomic impact studies. As I've already mentioned, we've completed this internally. We're expecting sign-off from the presidency this week, as well as approval to gazette all the policies for public comment. So next slide deals with the steps that are still to come. So step 8 is the public consultations on the policies, application forms, and fees. That'll take place in September and early October. Step 9, in October, prior to the 1st of November, we will gazette the final policies, application forms, and fees. We will open the application process online on the 1st of November, and it will close on the 30th of November. Prior to that, in October and in November, we will be conducting meetings and workshops, COVID restrictions permitting, and we will be using a hybrid of communication platforms to communicate with people how to apply. We've also requested the IT service provider to make sure that those that do not have the wherewithal to apply online, either because they don't have data or they don't have access to the internet. And here we have the Lionfish sector especially in mind. Most of the other sectors are sophisticated sectors, and we believe they will be able to apply online without any issue. But we will have decentralized services in all coastal provinces and coastal communities to assist people to apply online. The assessments will be conducted in December. Step 13, the announcements of the final decisions of the delegated authorities will happen in December, as and when the decisions are made by each of the delegated authorities. Those will be published in the general published reasons known as the GPR, and then in January, the appeals will commence and open. I think last slide is just to say that we've reassigned senior officials within the fisheries branch and from other branches to the FRAP team to assist. We have appointed 30 personnel on 2-year contracts to provide the administrative and secretarial and technical support to the FRAP management and delegated team, delegated authorities. And finally, in conclusion, we are of the view that the rollout of the FRAP project at the current pace, and noting the timeframes that we've just outlined, puts us on track to be able to deliver and meet the deadlines of 31 December, with the appeals commencing in 2022. But we do acknowledge that the timeframes are tight, but we are confident and are on track. Thank you very much.
Thank you very much, Sue. Honorable members, that is the presentation on the fishing rights allocation process. By sign of hands, can we engage the presentation? I see the hand of Honorable Bryant. Proceed, Honorable Bryant.
Thank you very much, Chairperson, and thank you to Ms. Middleton for the presentation. There are quite a number of points that I'd like to raise, if you'd indulge me. Firstly, in terms of the 12 fishing sectors that were mentioned, there is one notable omission, which is the Abalone sector. I'm a little bit confused as to why abalone hasn't been included. As far as I understand, abalone rights expired in 2013, and they've been operating on exemptions since 2014. There are a number of people involved in abalone fishing. We have divers, you know, across, particularly in the Western Cape, Part Norsterhout Bay, Kleinmond, Horst, and other areas. So I think those communities would be very intrigued to know why abalone hasn't been included as a 13th sector. And then if one looks at the milestones in terms of the appointment of the service providers, I know there are a number of issues relating to appeals dating back to 2016. I just want to find out how far along that process is. We have a number of challenges with small-scale fishing in the Western Cape in particular already. which I think also need to be dealt with. And I think a lot of these are central to the success of FRAP going forward. In terms of the IT and communication aspects, just want to find a little bit more detail in terms of the service provider. There is something online on the website that there says there was an appointment for a chartered accountant or provider for an amount of, I think, 5,275 Rand. Seems like quite a low amount of money. Perhaps if we can just get a bit of clarity in terms of that. What's the time frame for the build and the design of the online system? And, you know, is there already a system in place that's being used, or is there going to be a brand new system put in place? And how long is this going to take? Surely this isn't something that can be thrown together in, you know, a couple of weeks. Then if we look at the resource split, and we talk about the finalization of the apportionments, I know squid is, from what I understand, already in a bit of flux, and there are still appeals outstanding as mentioned. If we could just have a bit of comment as to that, there does seem to be a little bit of confusion around the apportionment with regards to squid. And, you know, the other question is, if these appeals are still pending, how can we, you know, proceed with that FRAP process? If we're also waiting, you know, for the final consultation with the white mussel and the oyster and the hake handline sectors. So we then look at the internal consultations for the review of the policies. This did need to happen earlier, as I understand, early 2019, to ensure that, you know, the allocation was done in time. So there's a bit of concern around that. The final policies that are due to be gazetted, are there drafts of these final policies in place at least? Is there something that, you know, is ready to go, or does that process also still have to start? And then if one speaks around the deadlines and that being considered by Cabinet, it is an ambitious timeline, and I think Ms. Middleton acknowledges that. And I understand that, you know, there is a great deal of urgency in getting this resolved, which I think is something to be acknowledged and commended. But I think one also has to be realistic in as much as there may be potential legal challenges if certain aspects of this process aren't properly complied with. And I think in particular, if we're looking at the socioeconomic impact study. So I would like to ask Ms. Middleton just if she could expand a little bit in terms of that socioeconomic impact assessments. There were, as I understand, due to be two phases. The first phase is being complete, and then there's a second phase which is supposed to take place, which is going to help to inform the outcomes of the process. And if you can just expand in terms of the conclusion of phase 1 and phase 2, and how important phase 2 would be to that process, and whether or not that should actually be completed before the process or the next phase of the process starts. And yeah, that, I mean, that is a very central aspect. And then just finally, Chair, you know, a really important part of what's going on at the moment, in particular with regards to lionfish. We've heard a lot of chat around exemptions and permits. and the exemptions put in place, to allow fishers to continue to fish in areas. But, the most recent set of exemptions, I think it was the 31st of August, the department came out quite strongly and said, there were no issues with the exemptions that were granted on that day. But, we found that the lionfish sector in particular were up in arms because they weren't included in that exemption. And we currently have the snook run taking place, particularly areas like Azefontein, and there are a number of boats that have been grounded. And, it's very, very important that we find out, as a matter of urgency, why those lionfish exemptions were not granted. There are people who are losing money hand over foot, families going hungry, because their boats aren't able to go out. And there doesn't seem to be any sensible reason as to why the squid exemptions were issued, but the lionfish ones were not. So I really would like some comment on that. There's actually an article in the paper today where the department then admits that there were issues with the granting of those exemptions. So there's just a lot of confusion around it. We have applicants from KZN, Richards Bay in particular, who applied for permits way back in February. And, this is the other issue. You have outstanding permits, February, March, April, people applied, and they just aren't hearing anything back. And it's creating so much uncertainty, so much anger. And I know that a lot of these people are looking at the options and saying, what else do we do? Who else do we turn to? Where can we go? Because the department just doesn't seem to be able to deal with and process these permit applications timeously. And surely, we should be looking potentially at, possibly devolving some of the authority to issue inshore permits, in particular, to competent provincial authorities. It's not a political proposal, it's an administrative one. What we want is to ensure that the sector, in particular the lionfish sector and the inshore sector, are able to operate effectively, and that the permitting process is undertaken smoothly and efficiently, and that people aren't sitting, sending out emails into the ether, not getting responses, and their industry, their livelihoods, the future of their children and their families being put at risk. So those are my questions, Acting Chairperson, from the first round. Thank you.
Thank you, Honorable Bryant. Honorable Singh.
Thank you very much, Chairperson, and thank you for the presentation as well. Honorable Bryant has covered a lot of ground, so I'm not going to repeat what he said. But just to say, while noting the presentation, I want to note the role of the political head, the minister in particular. Minister, I think you more than anyone else are aware that this matter has been on the table now for 20 years, since 2000, 2001, and we've got to bring it to a head sometime or the other. And one notes the timeframes that have been indicated in the presentation. But what I want to know is that, are we going to be assured as a committee in this term, and I hope it doesn't go to the next term portfolio committee, that some of the challenges that we've had, the challenge of ensuring transformation, meeting transformation targets, the challenges of ensuring that we deal with other development finance institutions to assist newcomers on the market, because cost of infrastructure and other acquisitions are going to be exorbitant. Are we going to ensure that fronting doesn't become the order of the day as it has become, where maybe 3 companies own 70, 80% of the market share and get all the fishing rights? I think these are the general questions that we have to be assured time in and again, that we're not going to make the same mistakes that were made 20 years ago. And it's not going to be fraught with corruption and all kinds of things that happened, with lawyers making a fortune and the departments having to sue them. So that's a general point, which I think probably the minister can also respond to in terms of hands-on approach on FREP. Then now we've got these targets, we've got local government elections coming, we've got budget cuts. I don't know if there's enough money to deal with appointing consultants and everybody else to be part of this process. And maybe we can be taken on that aspect, the budget aspect, the LGE and the impact it's going to have on the timetable. But I think I just want to re-emphasize that the objectives of the FRAP process, the targets, the transformation, etc., etc. Thank you.
Thank you, Honorable Singh. Honorable Mbata.
Thank you, Chair. Thank you, Sue, for the presentation. I see on page 8, on allocation of fishing rights, my worry is that we had presentation from the small-scale fisheries that came to the PC crying that they don't get the fishing rights. I hope when you talk about the allocation of fishing rights, they are also included, and they include everyone. And also when it comes to comments or public participation, I hope we have just, I have just raised those issues in the previous presentation. I'm not going to repeat them because it needs to cover everyone. And on the issue on the multidisciplinary members, I also just hope it covers everyone, including those who are the small scale, who will represent the small scale fisheries, and also looking at the youth, the women, people living with disabilities, because in most cases, women in the fishing industry, they are very few, they are the minority. But we have lots of women that have interest, and they want also to be part and parcel. I remember only one lady who attended our meeting who was from the small scale fisheries from Western Cape. And also, I also have a concern on the online system, but I'm a little bit covered, but not fully covered, because those who can't read and write can't use the online registration, and those without resources can use it. I think that will be handled accordingly, because we have so many disadvantaged people that will need to have fishing rights, despite of their education and so forth. And on the last one, on the personnel that you have employed to come and assist in the FREP, I will also wish that you have covered the youth, you have covered the women, you have covered people with disabilities, etc., so that it covers everyone. Thank you.
Thank you very much, Honorable Mbata. Minister, should I invite you to go first?
Thank you very much, Chairperson. Let me start with the question which Honorable Singh has raised, because I think that really it goes to the heart of what today's discussion should be about. Are we going to be able to run a clean, accountable, legally defensive process that is going to take us forward with regard to our transformation objectives? And I think, Honorable Singh, that is the objective here. And you will see that we have built in a lot of checks and balances. The first thing that we have done is that we have broken up the person who decides on the allocation the fisheries rights. What do you call that person, Sue? In terms of
delegated authority.
Delegated authority. In previous situations, there was one delegated authority. Here we have broken up the delegated authorities so that different people are responsible for different fisheries. And I think that we have also, as you can see, brought in a lot of support structures and a lot of structures that will assist us with checks and balances. And I think that all of this is to recognize that this industry is fraught with controversy. It's not a situation where you have a disorganized department and a happy, willing sector who are being abused. This is a highly, highly conflictual sector, and it's also a sector with a lot of vested interests, as you yourself have pointed out. And when you are dealing with that kind of process, it's very difficult to have fairness and to have transformation. The reason why we have worked on this question of the sectoral split is that although small scale are not involved in the process, unless we are allocating a basket of fish to small scale, the whole concept of the small scale will forever be a myth. And you can see that in the squid sector, where there are hundreds of small-scale operators who are desperate for a decent allocation, that one solves that problem after extensive negotiation with the industry, and one still lands up with a situation where the industry are challenging the decision, despite our best efforts to listen to concerns of the industry and to meet them halfway. So what I've come to understand is that with our best efforts, this allocation will be controversial because of the vested interests. Whatever we do, there will be controversy. I've come to understand that, and I've come to accept it. Honorable Mbata, this is one sector which I must say is the most participative sector of any sector in the country. We are inundated every day with text messages, emails, telephone calls, myself, and everybody, all the officials who work in the sector, because the sector really works hard on defending its turf and its interests. And I think that I can't give you guarantees, Honorable Singh. What I can say is I have tried to set up a process where the power is distributed and where there are watchers to watch the watchers. That's what I've tried to do. What I've also tried to do is to bring in additional capacity to deal with concerns around capacity. And one has also tried upfront to deal with some of the transformation issues so that you try and have those battles before you get into the actual rights allocations. I had hoped that some of the big players could have come to the party. But if they can't come to the party will have to go on. We will have to see whether the measures that one has taken to try and protect the process work or don't work. I'm not a person who believes in boasting in advance. All I'm saying is we're giving it our best effort. I meet this team every second week. I have met them every second week for 2 years. The DG meets them every week. And I think that while we get a lot of criticism, I've also had a number of role players, both at industry and small scale level, saying that there have been improvements in the way in which we work and in our responsiveness. And all we can do is to continue to try. And that is what we are going to do. We're going to continue to try. I'm going to allow Ms. Middleton to answer a number of the questions. DDG Legal, Ms. Benderman will answer the question on the appeals. Obviously, the 2015-16 process is not related to this process. It's a different set of fisheries, but Ms. Benderman will give you chapter and verse on that particular process. Thank you, Chair. Let me hand over to the team.
Thank you very much, Minister and Chairperson. I'll go through the questions that haven't been dealt with by the Minister in the order in which they were raised, starting with Honourable Bryant. Honourable Bryant, your first question was about abalone. And just to clarify, the presentation dealt with those fishing sectors that expired in December 2020 and are now going to be reallocated by December 2021. You are quite right about abalone. It's an outstanding fishery where a decision needs to be made. Just a correction, the rights expired there in 2015, not 2013. There was a decision at the time in 2015 not to allocate abalone rights because of the dire status of the resource. The abalone resource is under threat, and it continues to be so. So what we are proposing with abalone is to treat it as a separate fishery outside of the FRAP 2021 process. A decision will be taken on the future of the fishery, and there will be consultations on that. But we didn't want to muddy the process around abalone by squeezing it into the tight FRAP 2021 timeframes. So in short, we will be consulting with the current exemption holders around the future of the abalone fishery. We also have to take a decision about abalone allocations in the Eastern Cape, which have not traditionally been part of the abalone fishery. And just to complicate matters, abalone is also one of those species that qualify as a small-scale species. So we would need to decide whether it goes to small-scale or whether it continues as a commercial fishery or both. But just to emphasize again, we will be dealing with abalone, but separate from the 21 process. Just to clarify both to Honourable Bryant and to Honourable Mbata that the FRAP 21 process is dealing with commercial fisheries, not small scale. So South Africa has 3 types of fishing sectors, namely commercial, small scale, and recreational. FRAP is about the commercial allocations. It's an open competitive process, and you compete against similar applicants. Small scale is a separate process, a separate allocation process, but why we've done apportionment splits is for those species that qualify both as commercial and small scale. And in FRAP 2015, particularly around West Coast rock lobster, which was a dual species, both commercial and small scale, we were criticized for the fact that we did not announce upfront what the apportionment split would be between commercial and small scale. so that those applying for small scale at the time had no idea what amount would be available for commercial. And that is why we've done the proposed apportionment splits for squid, abalone, lionfish, oysters, white mussels, and hake handline, so that people know upfront prior to applying. Honourable Bryant, I'm not sure your reference to a chartered accountant that was appointed as a service provider. I'm not sure who you're talking about, but I can confirm that the IT service provider that was appointed is an IT specialist and not a chartered accountant, and that that IT service provider has international links as well. I can confirm that they are not building a new system. They are enhancing the current system that was developed as part of FRAP 2015, but just turning it into an online application process. So it's not a brand new system. They have started the development, and the testing of the system will take place in October, prior to the opening of the online applications in November. So we're on track in that regard. The Honourable Bryant, we did acknowledge that SASMIA, the South African Squid Management Industry Association, has appealed the apportionment split. They've also appealed my TAE decision for the current fishing season. The appeals authority is the minister. The minister has appointed senior counsel to deal with the appeal. The person dealing with, senior counsel who's dealing with the squid matter, is aware of the urgency, and we are hoping that a decision, minister will take a decision prior to December. So we're on track in that regard. Honourable Bryant, the review of the policies did commence in 2019, and a public workshop was held in 2019, well attended. And since then, we have developed and worked on the inputs received in that workshop that took place at the Lord Charles in Somerset West. I can confirm that all the policies have been reviewed and we have drafts in place ready for gazetting. You asked for confirmation or clarity on the sayers. So what we are waiting for is the presidency to certify phase 1. And as soon as we get certification, which we believe they have indicated that that'll be this week, we then run phase 2, which is your public consultation process, parallel to the public consultation process on the policies, because they're one and the same thing. Phase 1, where our process there was, we have been arguing to the presidency that we needed to review the policies through a public consultation process. So phase 2 of the sayers and public consultation on the policies and application fees are the same thing, and they run parallel, and that'll take place in September and with concluding in October. Honourable Bryant, you asked about the lionfish exemptions and permits. We are aware that you have tabled a parliamentary question on this matter. We will obviously be responding in detail in writing to your question. But I would like to indicate that lionfish was not included as part of the current exemption. An exemption was granted in September for 1 month for squid, permits for fish processing permits and import and export permits only. Everybody else is operating on permits that have been allocated. The exemptions were in place because of a backlog that we experienced during COVID. We have cleared that backlog, and it is not good practice to manage fisheries on continuous exemptions. Can confirm that the media article is misleading in the sense that there is not a crisis in lionfish. We have looked at the numbers. We are up to date in the allocation and issuing of permits. There were 15 that were outstanding that have been since processed yesterday and today. And there are a number that have been returned because of incomplete information. So we are within our time frame, turnaround timelines for the allocation and issuing of permits. Where vessels are not able to operate, that is because the SAMHSA requirements and the SAMHSA certificates have expired, and that is the responsibility of the right holder to review and renew their SAMHSA certification. Honourable Singh, I think that Minister has answered most of your questions. But on the issue of fronting and paper quota holders, part of the policy statements that we are about to release for public comment include our proposals on how to deal with fronting and paper quota holders. And obviously we would welcome any comment on this and whether it goes far enough. So please have a look at the general policy and all the sector-specific policies around how fronting and paper quota holders will be dealt with at a policy level. But to give you one example, what we are proposing is that there would be a moratorium on the ability of successful right holders to sell their rights for a certain time period. And the reason for that is to prevent fronting, so that you get paper quota holders who have no intention of being active in the fishery. They're put up by big companies to improve their transformation profiles and then immediately sell their shares or their rights. So one of the policy statements is a moratorium for 2 to 3 years on that, precisely to prevent that kind of fronting arrangement. But we would welcome your comments in that regard. Similarly, there are a number of policy statements on transformation, both in the general policy and in all the sector-specific policies. And again, we would welcome, those are precisely the areas that we are putting out for public comment, and we would welcome any inputs in that regard. Honourable Mbata, again, just to clarify that small-scale allocations are separate from the FRAP, and the Western Cape process does need to be concluded, and that will run as soon as there's a decision by the court. That process will commence. The small-scale application process will not be an online process. That will be community to community. Our development workers will assist people to apply. And yes, I can confirm that the people who've been appointed on short-term contract to assist us are a combination of youth, women. I don't think, unfortunately, that there was anyone with a disability, but definitely it's a young team. And that was quite deliberate because we do need to build up capacity to deal with rights allocation processes going forward. Oh, and then lastly, Honorable Singh, you did ask about the budget. It is a slide that we made, or a representation that we made to Cabinet last week. It wasn't included in the presentation, in this presentation to the Portfolio Committee, but I can confirm that the costs of the FRAP process are borne by the Marine Living Resources Fund. And we generate our revenue through licenses and permits and application fees that we receive from industry on a user pay system. So we have set aside a budget of 41.6 million for the FRAP process that is coming from our own revenue, so has not been affected by the national budget cuts. And we believe that that allocation will be sufficient. But also to mention that that budget will be partially recovered through the fees that we charge. So if you apply for a FRAP right, you pay an application fee. It's a once-off application fee, whether you are successful or not, and it's non-refundable. If you are successful, you pay a grant of right fee, and that varies from fishery to fishery, depending on the commercial and economic value of that particular fishery. And then you pay for your permit and levies. So we will redeem some of the costs, and it is a very expensive process. We will partially recoup some of the costs, and the rest will be borne by the public entity, the Marine Living Resources Fund. Thank you very much, Chairperson. I hope I have covered all the questions.
Chairperson, there was just one question. I think Honourable Singh asked about the local government elections. Honourable Singh, I suppose the only person who might be campaigning around the local government election is me. And you and other honourable members, but I will take a very dim view of any of my officials being involved in the campaign, and I don't, as to the very best of my knowledge, I don't think any of them are standing as ward councillors. So we're not expecting this process to impact on my officials. And if you get news of them engaged in these activities, please call me.
Will do. Thanks, Chair.
Yeah, thank you very much. I see the hand of Honorable Mbata. Is it an old hand?
It's a new hand, Chair. I understand the response from Sue, but what is my concern is that in the last meeting where we had the big companies here presenting, there was an issue that we had only one company that was owned by Blacks, and we had only one company that was owned by a colored lady. On those business people, it falls under FRAP. And us as parliamentarians or the portfolio committee, we would like to see those fishing rights, I'm referring to FRAP, being also given to the disadvantaged people, of which those are the Black people, and also females. Because the majority in those companies, those big companies, the Hague and them, are male dominated, and they belong to the white community. That's my concern, that how best as the department, and also assisted by the portfolio committee, that we make sure that we bring Black people we bring more women on the commercial fisheries. Thank you.
Honorable Bryant.
Thanks, Chairperson, and thank you to Ms. Middleton and the Minister for the responses. It's just one final question. It's just with regards to new entrants, particularly in the squid and rock lobster sectors. Are they anticipating a significant number of new entrants? Are there targets in this regard? Or with the tight timeframes, is it envisaged that there will be a lower number of new entrants? Thanks.
Sue?
Can I deal with those questions, please?
Sure.
Chair, Honorable Mbate is asking us to say yes, there will be new entrants. Honorable Bryant is asking us to say no, there won't be new entrants. And I suppose this is the divide between, this is what the debate on transformation is all about. I think as the department, as Sue has indicated, we are going to put out policies. Honorable members, as well as all other members of the public, will comment on those policies. But I'm going to say, Chair, that we're in the middle of a rights allocation process to predetermine in this meeting what the outcomes of that process will be, would compromise my officials who are involved in the process. So I think that what we are explaining is that all decisions are guided by policy. Policy is the subject of public comment, and we're asking that colleagues participate in that. But it's not right in this meeting to be asking us to be making concrete commitments. We hear what honourable members are saying, and I would just plead with you, can we leave it at that? We didn't take DDG Benderman. She was just going to speak on the appeals process.
Thank you, Minister. Thank you, Honourable Chairperson, Honourable Members, the DG and my colleagues. With regard to the pending appeals, there was a question raised regarding the appeals that come from the previous FRAP process in 2015-2016. We have approximately 68 Hague inshore trawl appeals that have been finalized. We have appointed an appeals advisory team comprising of senior and junior counsels who are assessing and will make recommendations in this regard. Their recommendations have been finalized. However, the technical advisory team on appeal on Hague are currently considering the actual rights allocation based on the scoring of the respective appellants. And once this is concluded, the Minister then will be briefed by the appeals advisory team and taken through the recommendations for her to then take a decision. We are sitting with approximately 58 horse mackerel appeals. This emanated from a legal challenge. We are halfway considering that with the appeals advisory team, and we are hoping to have these appeals concluded by November 2021. What we can confirm is all of these appeals that are outstanding from 2016, these appeals will be concluded prior to the new FRAP process commencing. Thank you. Thank you, Minister.
Thank you, Chair. That concludes the information on FRAP.
Honorable Bryant, is that the old hand?
Yes, my apologies, Chairperson. Thank you.
Sure. All right. Thank you very much, Minister. That brings us to the end of the discussion on FRAP. The next item there is the briefing by the department on UNFCCC. Minister Chrissy.
Chair, thank you very much. Our climate team is here. I think that Dr. Kumalo is here, and I think Marcela Kekana, as well as Klur Romaro. I'm not sure whether Jongi Witi is with us, but the climate team is here. Honourable Chair, I think that we've inserted a few more slides after we sent this presentation to honourable members. And I think we've done that because sometimes you don't realize when you are sitting working on these issues every day that colleagues maybe are wanting to understand the full architecture that government has and is putting in place to mitigate CO2 emissions and also to deal with questions of adaptation as well as financing. So we've included those slides really just so that we can, honourable members have seen this information in previous presentations, but I think what is really important is just to do a summary in one place so that colleagues can all be reminded exactly what this architecture is. And then we'll go into the actual negotiating issues for COP26. Can I hand over to Mr. Kekana, please?
Thank you, Honorable Chair and Minister, honorable members of the Portfolio Committee and colleagues. Can we move on to the next slide? The purpose of this presentation is to provide the Portfolio Committee with an update on the climate change negotiation and the proposed negotiating position. Next slide. Honorable members would have seen on the 9th of August a new scientific report on climate change that was released by the Intergovernmental Change, the IPCC.
Mr. Kekana, we seem to have connectivity challenges.
Hello, Minister. Am I audible?
You are audible now. If you break up again, we might ask you to just to improve your connectivity.
Okay. All right. No, that's fine. Maybe I remove the earpiece. Maybe that would work better. I use the computer straight. Yes, I was still referring to the IPCC report that was released on the 9th of August. And just to explain that this is the first report under what we call the 6th assessment cycle by the IPCC. We expect 3 more reports, the next one in February on adaptation, and the next one on mitigation, and finally a synthesis report still next year. And that would conclude the 6th assessment cycle by the IPCC. This is a report, or a cycle takes around about 7 years to conclude. So the IPCC has been compiling and reviewing this scientific literature for the past 7 years. The report was quite clear. The biophysical science basis report was quite clear that climate change results from global warming, which in turn is as a result of human activity. So this, as the report put it, this is now beyond dispute. The working group one report shows that the world will probably reach or exceed the temperature goal of 1.5 degrees of warming within the next 2 decades. However, the report also points out that with ambitious emissions cut, the world can still keep the global temperature rise to 1.5 degrees. Basically, the report also points out that climate change is affecting every region of the globe. However, the report also points out that sub-Saharan Africa can expect more frequent heat waves, heavy rainfall, fires, and droughts. So that is ourselves. And this obviously will have an impact on livelihoods, particularly on agriculture, water system, and the ecosystems. Unfortunately, such as the sea level rise will not be reversible for at least several centuries, even after emissions fall. So this is the report, the latest scientific report that came out that urged for urgent action. And just to recap what we are doing in South Africa, some of the activities and actions that we put in place, members would know that we now have the Presidential Climate Commission, which is dealing or developing some pathways to low carbon climate resilient society. Under the Paris Agreement, we have the nationally determined contributions that set emissions targets for the years 2025 and 2030. We also have the National Climate Change Response Policy of 2011 and the bill that was mentioned earlier on. There is also Integrated Resource Plan of 2019. This is the Electricity Plan for 2030. From the National Treasury, we presented in this committee this carbon tax, which was implemented from 1st June 2019. We also have other policies such as energy efficiency and the green transport strategy, the low emissions development strategy that was submitted to the UNFCCC that talks to the issues of net zero emissions. We have the industry master plan for renewables, electric vehicle, and talks and address the steel sector as well. There are various tax incentives for energy efficiencies, renewable energies, biofuel production, research, development, and innovation. There's carbon offset administration system, which is linked to the carbon tax. And of course, we also, from the department side, have a mandatory national greenhouse gas reporting regulations. This is a basis for carbon tax and greenhouse gas emission reporting to the UNFCCC. And the mitigation architecture that was presented previously has got several components. The first one on the left, where we've got the mitigation goals. This is around national greenhouse gas emission trajectory range, against which we measure the outcomes. We also have the monitoring of greenhouse gas emission that talks to issues of data collections, the GHG inventory, and the monitoring and evaluation system. In the middle, we've got the sectoral targets. These were previously known as desired emission reduction outcomes, but they are now called sectoral emission targets for each significant sector or subsector of the economy. We also have the industry emission limits. This is adopting a carbon budget approach to provide for flexibility and least cost mitigation sectors and or subsectors. And finally, on the right, there's industry implementation, where we have mitigation plans to demonstrate how mitigation by companies is to be achieved. So these are the plans that are submitted to the department. There's also various sector policies to drive mitigations, such as policies and measures, economic measures to drive mitigation. Some of them I've already mentioned, such as the Integrated Resource Plan of 2019 and so forth. So that is the overall architecture of the mitigation system. And on the adaptation side, this is adapting to the impacts of climate change. As part of mainstreaming climate change into planning framework, aspects of have been included in the Disaster Management Act. So we work closely with those colleagues. We have the National Climate Change Adaptation Strategy that was approved by Cabinet and is currently being implemented. There's also climate change sectoral adaptation plans, which have been developed by the following sector at national level: the water, agriculture, forestry, fisheries, health, biodiversity, and we have the climate change policy framework for state-owned companies and rural human settlements. All 9 provinces have developed climate change response policies. The department has also assisted all 44 district municipalities and metros to mainstream climate change into integrated development plans, the IDPs. So that is the work that we've been doing with various sector departments and the provinces and the district municipalities. Next slide, please. And so what is the sources of support? We've noticed that there's budgetary allocations that deals with issues of supporting climate change action, but some support comes through bilateral donors. We also have multilateral development banks that provide support, but there's also private sector support through foreign and domestic investors and so forth. Next slide. So having said all that and outlining the architecture, and I believe my colleagues provide updates under a general framing, which we normally refer as the progress on implementation of the Paris Agreement or the nationally determined contribution to both the portfolio committee and the cabinet. Having said all that, the business for today, it's what we've always said, that no single country will keep us safe. We need all countries to do their fair share on climate change. Therefore, the multilateral approach on dealing with climate change remains relevant. And in particular, our convention, the United Nations Framework Convention, remain the main instrument for implementing a climate change solution, especially now with its Paris Agreement that was negotiated and adopted following COP17 in Durban that laid the foundation and provided a platform for 4 years to negotiate this Paris Agreement that was eventually adopted in 2015. So the multilateral approach and the UNFCCC in particular remain relevant globally. And just under the Paris Agreement, as we have come, all of us have come to understand and recognize now, each and every country is expected to submit its national plan or the nationally determined contribution, as we call them, every 5 years. So this was the agreement from Paris in 2015. And this plan must contain mitigation target, but can also include or contain adaptation measures and support needs from our sides. This is important because every 5 years we have to review the impact, the collective impact of all these NDCs vis-a-vis the goals that we've agreed to under the Paris Agreement. If the overall mitigation effort is inadequate, then countries are expected to take this into account when submitting their next round. Hence, at the current moment, we've been engaged in revising the NDCs that were submitted prior to the Paris COP in 2015 because the NDCs were deemed insufficient in relation to the new information that is coming from science. So next slide, please. So we will be continuing with the discussion or the negotiations, the multilateral approach under the UNFCCC through the 26th Conference of the Parties in Glasgow. We all know that last year we did not have this conference because of COVID-related reasons, but we've received assurance from the UK that the COP will go ahead as planned in Glasgow this year. We have also received assurances from the UNFCCC Secretariat that, go back to the slide. From the UNFCCC Secretariat that the preparatory meetings will go ahead in a virtual format. We know last year, even though we did not have the COP, we did have virtual engagements, which were not necessarily negotiations, but an exchange of views by various amongst parties, just to advance the issues that are still on the table for negotiations. And we had the June momentum to replace the normal intersessional meeting in 2020. And in December, instead of the COP, we had the climate dialogues. And this year, again in June, because we could not meet in person, we did have the subsidiary bodies, but this time was a little bit more engaging. We were in a negotiation mode because Glasgow is just around the corner. It was important that we prepare for the COP that will take place on the 31st of October to the 12th of November. Next slide. So the next couple of slides really talks to the expectations from our side. South Africa still expect the negotiations to be transparent, inclusive, and take place in a balanced manner. So no issue should take priority over the other. But in particular, our drive and resolve is to secure new commitments of support by developed countries for implementation by developing countries that would assist us to address both mitigation and adaptation. However, we would recall that there are still outstanding negotiating issues, technical negotiating issues that are necessary for the implementation of the Paris Agreement. And these issues relate to issues of market approaches or carbon markets, or what officially is called Article 6 of the Paris Agreement. But our focus in these particular negotiations, our biggest priority is to secure a share of proceeds for predictable financing for adaptation. We also still have to conclude the elaboration of common reporting formats and tables, as this will enhance transparency and understandability of the party contributions on mitigation, enhancing mutual trust, predictability, and making it easier to aggregate the collective impacts against the global temperature goal. So this is the reporting, enhanced reporting under the Paris Agreement, which really forms the cornerstone of the Paris Agreement, because the Paris Agreement is a bottom-up system where countries bring forward their offers, as opposed to the previous regime where we had a bottom-up system with agreed targets that were then allocated to various countries. Under the Paris Agreement is a different system. Therefore, the transparency or the reporting becomes for mutual trust. We also have to conclude the issue of common timeframes for these NDCs, as much as we agreed that every 5 years we'll submit new NDCs. we never agreed on the implementation period for these NDCs. Hence, you'll see some of the NDCs have a time period of 5 years and others have a time period of 10 years. So we have to agree on that. Also linking to the discussions on carbon markets, the issue of common time frame. From the Africa perspective, adaptation remains our key priority, and we've been calling for a work program to operationalize the global goal on adaptation, and we will continue to pursue that. We've written submissions to put this on the agenda of the COP, and it is currently on the draft agenda that was released this week. We will fight very hard to make sure that it remains on the agenda so that we can track progress on issues of adaptation. We also will be focusing on the clarity and commencement of the process that will determine the new and more ambitious goal for long-term finance, increasing beyond the current agreed 100 billion per year. And this new finance goal is meant to kick in from 2020. So the 100 billion per year from 2020 will continue. It will be stretched up to 2025 until there is an agreement on the new finance goal. Next slide. So that in a nutshell, those are the key priorities that we'll be focusing on. The delegation has been working very hard, a team of negotiators coming from various sector departments that have been engaged on these issues, have been working very hard, formally and informally, in the Africa preparatory meetings, in the G77 meetings, but also more importantly, in informal negotiations with our partners in preparation for Glasgow, so that we can be able to bridge some of the divide on these key issues. And we are assisted, or the team comprised of various colleagues from sector departments and research organizations, just to name a few, but this is not a comprehensive list. We've got people from mineral resources and energy, trade and industry and competition, colleagues from transport, colleagues from water, colleagues from science and innovation, special research organization and academic institutions, and National Treasury has recently joined the team as well. So we have a set of experienced negotiators. We'll be continuing these discussions in Glasgow. The UK COP president has also announced that it will host a one-day leaders summit on the 1st of November. You might have seen the earlier dates for the COP, which were 1st November to 12th November, have now been changed to 31st October to 12th November. It's precisely because of this one-day leaders summit where the heads of states have been invited to this particular summit. And the objectives for the summit are quite clear, which we agree with, including raising ambition, accelerating climate action, and providing general political support and momentum for the negotiations. And as usual, parliamentarians will also be meeting under the Inter-Parliamentary Union, which will be taking place on the 7th of November 2021. And we are hopeful that the South African team will also participate there. Working with the business sector and the NBI, National Business Initiative in particular, we are preparing to have a pavilion. We're still in discussions with the UK because of the costs that are involved there. But the plan is that we will this year have a pavilion where we can showcase the advances that we've made on climate change action by both government and business. We want to provide a platform to demonstrate this collaborative action between government and business, but also the pavilion is important because that's where we provide an opportunity to tell the story of South Africa on climate response. Many other countries do the same. In the negotiations, we are normally bogged down to negotiating the modalities, provisions, and so forth. But in these pavilions, that is where we really can showcase and tell the story from the South Africa's perspective. We also want to bring the issue of the just transition forward, particularly the concerns between developing and developed countries. The pavilion will provide an open and interactive space for different stakeholders to engage closely. And in this regard, we've received support and requests from a number of civil society, business and other African colleagues, the African Union and other governments to share space where we can tell an African story through this particular pavilion. So we are hopeful that the negotiations will go well and the pavilion will be up and running in Glasgow. That is all, honorable members. I think this is the end of the presentation where we were just updating you on the preparations for this and sharing some of the negotiating positions with yourselves. And we look forward to interactive discussions. Thank you very much.
Thank you very much, Mr. Kekana. Honorable members, it is now the opportunity for us to engage the presentation made by the Climate Change Negotiation Team. By sign of hands, I see the hand of Honorable Bryant. Honorable Bryant, please proceed.
Thank you, Chairperson. Chairperson, just let me first say thanks for the presentation. It really is good to see government taking note of the science and following, the science as the kind of guiding light and not necessarily kowtowing to vested interests as we do tend to see in some parts of the world and potentially, possibly previously in some instances. I think the main issue obviously is ensuring that we keep up the sense of urgency. If one looks at what's happening across the globe in terms of changing climate, the disasters that are taking place on a more and more frequent basis, I think it's hitting home the urgency that is required in terms of our responses, not only for how we adapt now, but how we potentially mitigate going forward for our children's futures and their children going forward. Just a couple of points, in terms of the setting of the NDCs, setting NDCs is the easy part. It's the compliance with the NDCs which seems to be the challenge for South Africa and for our government in particular. And I think that is something where we need to ensure that we put the bulk of the priority, not just in terms of setting the targets, but compliance with those targets. That really is the real challenge. And then just in terms of Article 6, I think we do need to have a concerted focus on fleshing that out. It could be an entire presentation on its own for us to understand as a portfolio committee the implications and the inner workings of that particular section, and ensure that it's something that we can come to grips with and fully understand. And then just finally to say, Chairperson, that we certainly share the goals and the ambitions that have been set out, and we will assist ourselves as a DA caucus where we can to help and achieve those goals. I think climate change is such an urgent issue. It requires a response and a cooperation across the board because we don't have the luxury of time anymore. As so clearly articulated in the latest IPCC report. Thank you, Chair.
Thank you, Honorable Bryant. Honorable Singh.
Thank you very much, Chairperson, and thank you for the presentation by Mashabande and to the Minister. I think, as Honorable Brian says, I mean, climate change is upon us. The impact and effect on ordinary human beings is well documented throughout the world. And having these kinds of conferences is a good thing. But one continues to live in hope that the plans and the decisions that come out of there are just not good to read on paper, but they are implementable, not only on an international scale, on a global scale, but within countries itself. Now, I think I stand to be corrected, but I think we have the unenviable position. It would have been nice if it was to do with Olympic medals, gold medals, etc., that we're #1 in the world. But I think we're #1 in Africa when it comes to being the biggest polluter. And that's not a good thing. So what I'd like to know, just some general questions on this is we know that these agreements are said to be, and the Paris Agreement is legally binding. It's a legally binding international treaty. Now, to what extent can one take legally binding? Are there sanctions that are imposed? And have there been examples of sanctions that have imposed on those that do not comply? We know, for example, America with its last president was one of those huge countries that ranks amongst the top 10 of the most polluting countries in the world that did not comply. But I think with the change in presidency, there will be a change in terms of how they look at the Paris Agreement. And then, perhaps just to move on to the funding, we get all these developed countries asking us to do A, B, and C and promising all the fund in the world. Is this funding coming to the extent that they promise? I mean, we've heard about 100 billion. I mean, how much of it do we get as South Africa? And that brings me to the next question, which Dr. Kumalo spoke about, is that, as African countries, there's this whole debate on just transition and what it means to developing countries like ours. Now, when we go into these international conferences, and I've been to many agricultural and other environment conferences, etc., you normally take a sub-Saharan Africa position. You talk to each other in sub-Saharan Africa, and then you take an African position. Is that what the case is going to be when we go there, in addition to us putting South Africa's response to this climate change agreement on the table? And then just internally, I mean, I don't know, we had a briefing last week on the science of climate change and everything else. Are we really satisfied with the pace of change in our own country? When you look at the presentation we received from Eskom and Cecil, particularly Eskom, it didn't leave us with much hope, because most of their factors to ameliorate the excessive pollutants in the air was based on financial implications. And they said, well, we don't have the finances to do A, B, and C. And lastly, do we think we are doing enough as a country to bring to the fore, to the ordinary man on the street, the impact of climate change? Not only on the industrial sector, on the corporate sector, on township developers, but what we as ordinary citizens in our everyday life can be doing in some small way to ameliorate the impact, the negative impact of climate change on society. Thank you very much, Chair.
Thank you, Honorable Phillips.
Good morning, and thank you so very much for the presentation. I always get excited when I listen to these presentations, and I think, yes, somebody finally gets it. But I think I need to echo what two of my colleagues have said. We have these presentations and we have the policies, but on a local level, the compliance is not actually there, and the people don't understand the importance of the climate change. You know, everybody says, oh, but it's you know, there are more important issues, or else we have municipalities that can't get the basics of for water, electricity, and sanitation right. So there's no way that anybody actually even expects them to get climate right. So I don't know how we're going to approach that, but we really need to make compliance more important, and we also need to make education of not only our citizens, but also of our local government officials more of a priority. Thank you so much.
Thank you, Honorable Phillips. Honorable Mbata.
Thank you, Chair. Thank you, Mr. Kekana. I think this is a good presentation, but I would like to raise, because you spoke of the renewable energy and energy efficiency, because when we talk of the renewable energy in South Africa, we have such, and I know that it's being done, because we depend on wind, we depend on solar energy, of which when you look now, it shows, I'm putting some of the input to say we have done something as South Africa, because on the new RDP houses, you'll find a solar energy being installed so that it assists. And we have hydropower. And I know that there are areas where there's too much wind, where that wind can be used for energy. And we have biomass also, because hydroelectric, I know the electric cars are there. I've seen it at Brooklyn Mall, where communities that have the electric cars, they come and they're allowed to charge that. And the most important thing is that these are the things that we should be trying to emphasize as South Africa, in order for us to comply to mitigation of to climate change according to Paris Agreement. Because if you look at South Africa currently, we are producing approximately 40% of electricity, but that 40% of electricity is being produced through coal by Eskom, which contributes to the climate change and the air quality. And then if you look at that, it says we are the 11th highest emitter of greenhouse gases in the world. That means we've got a lot to do. Being the 11th in the whole world, it says something. Because I know Department of Public Works, they are doing the energy efficiency issues, where they look at the usage of LED bulbs and compass fluorescent lights, that they are removing the old ones and putting these ones, which assist in the reducing the energy. And if you look at some of the private companies, the producers of the refrigerators, the washing machines and all those, they have that thing that say energy saving. So these are the things that we should, as the portfolio, try to, and the department, try to take it out or empower the communities so that they can also assist the government in reducing, in order for us to comply to this climate change. And let me tell you, the Western Cape already has a company that deals with waste to energy. It's only in Cape Town. And if you look at the waste that we have piles and piles and piles of waste. Before, I usually say Japan is doing this. But I'm happy now we have one company that is doing it in Cape Town. If that company can do it in Cape Town, why can't we do it? Because it will assist us to save to comply on climate change, and also assist in saving the energy. Because in order for us to deal with this thing, part of the things that you mentioned is renewable energy and energy efficiency. But how do we create awareness to our communities in order to comply to this, especially in the locations and the suburban areas? But we still have a long way in the areas where it's the rural areas, where they still use the wood and the coal, and also somehow in the township. Those are the things, although we have done something, those are the things when we're supposed to be working with other departments that we need to emphasize and make sure that that's where we put more emphasis so that we comply to the Paris Agreement. Thank you.
Thank you, Honorable Mbata. Honorable Mkunu.
Thank you, Honorable Chair, and greetings to Honorable Minister, Deputy Minister, and the team, and the honorable members. I think I'm covered by the other speakers. Mine is just one on the issue of the financing, that the team that is going to Glasgow should really be trying hard to emphasize on the financing of these programs, the programs that the Honorable Mbata is talking about, of renewable energy and dealing with all the issues. Because I'm glad that we are now saying the current government of USA is now back on board, so that we can see, because they need to assist the developing countries so that we can be able to deal with the issues of the climate change, the issue of the greenhouse emissions. We've got to negotiate harder. That's my point that I want to emphasize, and also to the Honorable Minister, that we need to really look for funds, because as a country, I know we can do some of the things, but we need assistance of those developed countries, and those that have been producing a lot of emissions that are affecting the climate change. Thank you so much, Chair.
Thank you, Honorable Kunu. Honorable Phillips, is the hand old?
Sorry, yes, Chair, it's old. I'll take it down. I'm just going to find it.
All right. Honorable Minister and the team.
Thank you very much, Chair. Let me make a couple of comments, and then I'll ask Marcella to deal with the detail of the questions. Chair, I think that the first question that honourable members across the board are raising is, what is our country going to do to contribute to reducing greenhouse gases, but also what is our country doing to deal with the realities of the fact that climate change is already here? So how are we facilitating adaptation? And I would want to say that we will very soon be bringing to the Portfolio Committee the revised nationally determined contribution that we are going to deposit with the UNFCCC. This process, as you know, we issued a first draft there was public consultation, there's been input by the Climate Commission, and now what we are doing is synthesizing all the issues. And I think Honorable Singh raises a very important question, and others have also raised it, about what are our responsibilities in terms of implementation. And obviously, the first thing that you've got to do is you've got to make sure that what you are committing yourself to is implementable. And that's why this process is not just a process of thumb sucking a number and then just putting that number out in the public domain. It has to be a process where one goes into research. What are different sectors of the economy doing? What is ESCOM going to do? What does the integrated resource plan say? And so on and so on. So, because if we research it properly and if we have proper plans, then we can do with what Member Bryant is raising, is we can comply with the NDC that we put out. Honorable Singh, NDCs are not legally binding. You have an obligation to submit them, but they are not legally binding. And I suppose Mr. Kakana can talk about whether there's any other enforcement mechanisms under the Paris Agreement, but the NDCs are not legally binding. But obviously, in this context, in our country, there would be lots of pressure from everybody who is worried about the future of our country. And so we want to try and put forward an NDC that we can comply with and that we can implement, because the president has given us very clear guidance that South Africa must do its bit to reduce greenhouse gas emissions. Now, when we talk about the fact that our country is the biggest emitter on the continent, it's very important to remember that overall, although we are the 11th highest emitter, in total numbers, we are only contributing between 1% and 2% to global emissions. So obviously, there are other countries that have created this problem, because this problem starts with industrialization that happened in the 19th century. And we all understand that it's the developed countries that have created this problem. And therefore, there is a lot of imperative that the developing countries have to do more. And you would see that pressure being exerted globally. I've only been involved in this area for 2 years, but I can share with members that there has been a tremendous change in global attitudes over the last 2 years. I think that the science is making tremendous impact on public perception and leader perception. And you would see amongst developed countries a lot of commitment to what they call Build Back Better. So after the COVID pandemic, a lot of developed countries are saying that as we recover from the pandemic, our recovery will be a green recovery. And that obviously poses significant risk for South Africa if we do nothing, because already the EU and a range of other countries are talking about carbon border tariffs. Now, what we understand is that electricity is an input into all of our exports and all of our services. So obviously, even if in the World Trade Organization, developing countries fight against the implementation of these carbon border tariffs, consumer demand is driving this issue. And you would see that consumers are saying to their banks, tell us that you are not investing in fossil fuel initiatives, asking their supermarket, what is the carbon footprint of this product and that product? So what we understand is that even if there aren't formal tariff barriers, carbon tariff barriers, our economy is vulnerable to what we call the transition risk, which is this risk that our goods and services will no longer be competitive because consumer demand is wanting to understand what is the carbon footprint of different goods and services. And so it means that not only does our country have a moral imperative to contribute to reducing greenhouse gas emissions, we also have economic interests in doing so because we want to ensure that our goods and services are most effective. Now, in this regard, Eskom has been doing very, very interesting research work, which we have been supporting into the coal-fired power stations that are due for decommissioning. What would be the implications of decommissioning these coal-fired power stations? And this is where the concept that honorable members have raised about the just transition comes in. If you're going to decommission a coal-fired power station, and you're doing it because it's part of your global contribution to reducing greenhouse gas emissions, the question that arises from that transition process is who pays the price for that decision? And the concept of climate justice means that the workers who work in that coal-fired power station and the community that is part of the economic ecosystem of that coal-fired power station. So if you take Komati, which is the proof of concept project that we're working on with the Climate Commission, you know that everybody in that community either works for the power station or works for a service provider or a supplier of that power station. So the question is, what can you do to repurpose that power station? What can you do to stimulate additional industries in that area? And how do you work with the workers who are there at the moment to reskill them so that they can take a different set of jobs? So that is the concept of the just transition. It's a concept that is embedded in the International Labour Organization, and it basically is saying that workers and their communities cannot carry the burden for this transition. So this is interesting work that is being done at the moment with Eskom, and I think it's the broader work that the Climate Commission is seized with, is to say there's 7 sectors of our economy that are vulnerable. How do we start to research and define the pathways that will get us to this mid-century commitment to a low carbon economy and a climate resilient society? Because at the moment, it's a commitment, but it's more of a wish than a commitment. It doesn't become a commitment until you can actually say, this is how we're going to be transitioning each of those 7 sectors of our economy. I think that a number of colleagues have raised this question about local government. And you will see, and I think that, we could have given several more slides where we talk about the support work we're doing with local government. We have worked with all of our local governments to try and support them to develop climate change strategies, both in terms of adaptation, but also particularly in the case of the metros that have big industrial bases, how they're going to contribute to mitigation. And it's an important ongoing area of support. And this would also relate to the important issue that Honorable Mbata has raised about waste and waste management. I recently was invited to a meeting with the city of Johannesburg, where they wanted to consult us about waste to energy issues, because I think, we are constantly singing a song that our landfills are becoming full, and that landfilling is not an environmentally appropriate way of dealing with waste going into the future. So, Honorable Mbata, this issue is it's a local government competence, but it's definitely an area of very important advocacy work. In terms of the African continent, you would know that for the past 2 years, I've been the president of AMSEN, which is the African Ministers of Environment. And we are responsible for working with what is called the AGN, the African Group of Negotiators, on exactly what would be the negotiating position of the African bloc on all matters, but specifically on climate change. Honorable Singh, for the majority of countries in Africa, they are not big emitters, but they are the victims of climate change, because what we know is sub-Saharan Africa is warming up at twice the global rate. So extreme weather events, drought, wildfires, these things are decimating sub-Saharan Africa. And even, regions such as the Sahel and so on have been devastated by drought. So the issues of adaptation are the key issues for the African continent. And in this regard, Marcel has spoken about the fact that the big problem at COP is everybody wants to focus on mitigation. They don't want to focus on adaptation. But the truth is, for developing countries across the world, climate change is actually threatening achievements in terms of the Sustainable Development Goals. These extreme storms in the Caribbean are wiping out whole cities overnight. The adaptation question is very, very serious. And linked to that is the financing question. Because when you have a tropical cyclone in Mozambique and a city like Beira is wiped out in 48 hours, who's going to pay to put it back? Because Mozambique doesn't have the tax base to sustain that kind of investment. And so the question of financing is very key. And I think honorable members have asked the question, are the financing commitments being honored? And the answer very simply is no, they are not. There was a commitment and there is an obligation in the Paris Agreement on developed countries to provide means of implementation for developing countries. And the goal that was set by 2020 was $100 billion per annum. It hasn't been honored. It doesn't matter which way you count it, it hasn't been honored. And we're now in a situation where we're moving to the post-2025 environment, and we are saying, so what is the new commitment? Because OECD research is indicating that developing countries are going to need $3 to $4 trillion in the next 15 years to adapt to climate change. So where is that money coming from? And when we went to the UK, we put it to that collective of ministers that the new post-2025 target for financing needs to be $750 billion by 2030. Then we are starting to talk about figures that actually can help us to achieve what the OECD is indicating will be needed. Obviously, not all that money is going to be grant money. It's going to be concessional financing, loans, blended financing, public and private money, and so on and so on. But that is the level of mobilization that is needed. So, last point I would just want to make is really about this question about what are we doing for ordinary people. And I think that in addition to the work we're doing with municipalities, so that we're starting to mainstream the adaptation strategies into municipal budgets, so that we start slowly over a period of the next 10 to 15 years to be weatherproofing our infrastructure and so on. I think the other thing that we had wanted to do with SAWS, the Weather Service, is to start conducting education in rural communities so that people understand what exactly is happening with regard to the situation. Because, you know, we've got 2 to 3 million people who are dependent on subsistence agriculture in this country. The drought that is going to become perennial is going to pose a significant threat to subsistence agriculture and, of course, to commercial agriculture. So we want those communities to understand what's happening to them. We want them to understand what alternatives there are in terms of more drought-resilient processes and so on. And we really want a situation where there's a better level of understanding. Unfortunately, that program was disrupted by the COVID pandemic because it has to be a face-to-face program. But I think once we evaluate that it's suitable and safe, we will reinstate that program because it's very important. Let me pause there and hand over to Mr. Kakana to deal with some of the other nitty-gritties.
Thank you, Minister. I think you've answered quite a lot of questions. There's just two that I'll deal with. The first one on the sanctions. As Minister has pointed out, the architecture of the Paris Agreement is quite different to the architecture of the Kyoto Protocol. However, we still have a compliance committee under the Paris Agreement. The compliance committee, although will not sanction any country, but it's got the responsibility to check whether a country is complying with its obligation. And we know that the legal obligation under the Paris Agreement is to submit the NDC, is to submit the follow-up reports, such as the biannual transparency report that shows exactly the progress that the country is making. So the compliance committee will evaluate whether you have submitted your NDC. If not, it will ask you a question whether when are you going to submit. But it will also check whether you've submitted the transparency report and advise you in that regard. So the whole Paris Agreement is based on encouragement, solidarity, global solidarity in that regard. So there's no single country that has been sanctioned. In any case, the implementation of the NDCs is only starting in 2021, and the first reports will come in 2023 in that regard. So as much as there's no sanctions that you will receive from the compliance committee, however, the compliance committee will still call you to account in terms of your legal obligations that you have. So that is what I can say on that. And with regard to the question on Article 6, just to give a brief summary, the Article 6 is divided into three parts. The mechanism, which is more like what we know and are familiar with, which is the old clean development mechanism. And then there's another part which is new, which is cooperative approaches, or what is called Article 6.2. And then there is a non-market mechanism, which is the third pillar under Article 6. And what are the problems with this? Why is it not being concluded? There's three issues under Article 6. The first one is the transition. The whole question of what do you do with the units generated under the clean development mechanism? How do you transition them into the Article 6? So there's huge differences there, with some countries wanting to transition all the units generated there, and on the other side with others saying, no, this is a new regime, you are going to flood the markets, the price will still collapse, and we'll go back to square one where this mechanism is not working. Then there's a whole issue of accounting. How do you account for the transfer of units generated under this market? So this is where the issues of environment integrity and double counting comes up. There's a huge set of issues around that and huge differences on that. And finally is the whole issue of financing. Under the Paris Agreement, we have a clear commitment for countries to, or when the units exchange hands between countries, to have a share of proceeds. But this only applies to the first part of Article 6, which is the mechanism. We do not have such a provision under 6.2. However, developing countries and African countries in particular have put forward a proposal that we need to have a similar share of proceeds on these cooperative approaches. That is where there's this huge differences now on that particular issue. So the issue, those three set of issues are not resolved. And we are hoping that because of the negotiations that have been going on since last year, formally and informally, we will be able to reach some level of agreement or minimum agreements with the bulk of the issues packed under a work program for further deliberation. So that is what I can say, Minister. I think all the other issues, you've covered them quite well. Thank you.
Chairperson, just one thing, this is just information for colleagues. I know that after we finished here, you will be having your own discussion on your delegation to COP26. Just to advise that the sooner you can sort out your logistical arrangements, the better, because we told that accommodation is not easy to find in Glasgow. And the other thing is colleagues need to really appraise themselves of the COVID environment in the UK. I think that there may be some requirements for a reduced quarantine period. South Africa is a red listed country. So we would just want to advise you to get full information on that matter well in advance, because it's quite complicated. And I can say to you from my own trip to the UK, I think I was there for 5 days. I had 7 COVID tests. So it's complicated. So colleagues should really just get full information about that, and full information around things like when you leave, you'll also have to have a COVID test for your return to South Africa, and it's quite expensive. So just it's just a friendly word of advice. Thank you.
Where's the chairman now?
Yes, I'm here. Thank you very much, Minister. Thank you very much, Ntate Maisela. Can we move to the next item now, which is
Can we be released, Honorable Chair?
That is true and correct, Honorable Minister.
Thank you. Thank you very much.
We will now deal with the business of the committee. As they are living quietly and nicely. Can I request that we flight the minutes of the 31st of August?
Those are not minutes, Chair, that's agenda.
These are draft minutes, Honorable.
Okay.
All right, without further waste of time, honorable members, these are the draft minutes of the portfolio committee of our PC held last week, Tuesday. Can we deal with them page by page? This is the first page.
Chairperson, sorry, I think I attended. My apologies on that day.
Can you go a bit down, is it Nhlanhla, so that we check if the apology of Honorable Singh was not tendered?
I seem to be marked as present on the top.
Pitile apologies. You must go back up because there's apologies. It's only Holomisa and Kalo.
All right, can we first fix that page? Honorable Singh had tendered this apology. He deliberately did not want to vote.
I'll take you up on that one when I meet you.
All right, it will be corrected, honorable members. Can we go to the next page? Can we go to page 3? Can you move to the next page? I believe this is the last page. Honorable members, can I check if these minutes are the true reflection of what transpired in that meeting?
Chair.
Honorable, I see
It's
the hand of
Ganjo.
Honorable Mkunu.
Oh.
You are noted, Honorable Ganjo. Honorable Mkunu.
Thank you, Honorable Chair. These minutes are a true reflection of the meeting. And if that is the case, and I wish to move for its adoption.
Honorable Ganjo.
I second, Chair, the move for adoption of the minutes.
Honorable members, the only amendment effect that's going to be affected there is to correct that Honorable Singh had tendered his apology for this meeting,
Apology, yes.
and that the minutes are a true reflection of what actually happened in that meeting. With the minutes having been seconded, can we move to the next item? The next item is committee deliberations on the multi-party delegation to the UNFCCC COP26 conference in Glasgow. I think we're all aware of this conference after also having received the presentation from the department on their state of readiness and the level of the negotiations that they've been undertaking. I must, from experience, give the background that this delegation is actually decided in the office of the chairperson of chairpersons, Honorable Frolik. But I want to just open this item for members to ventilate whatever views that must be deposited or whatever that members would like to share with the office of Frolik. It be noted as a decision of the committee. By sign of hands, can I see if there are? I see the hand of Honorable Mkhuni. Is it an old hand?
Hand, it's an old hand.
All right, we'll take Honorable Dave Bryant, followed by Honorable Naren Singh.
Thank you, Chairperson. Chairperson, I did previously raise this matter with the previous Chairperson, Klasa, informally, to find out, whether or not the committee was intending on sending a delegation. And he said that Frolic hadn't received an application or a request. I then further followed up and spoke to the minister about it, and she said that we, would need to resolve on something within our committee, and then that to go through to Frolic to state that, it is our intention to have a multi-party delegation from the committee present. So I think that would just be something we'd have to then resolve as a committee to get, to get that request through. But in terms of the compliance issues that were raised by the minister, I think those are very good points. And I think the best way for us potentially to deal with that would be for our committee secretariat to urgently look into what the requirements are. And then, once we've decided on the size of the delegation or, whoever is going to determine that, our own WIPs can then establish and determine whether or not, our individual members would be compliant, i.e., have all members been fully vaccinated, the potential quarantine times. As I understand, I'm not sure if Glasgow has a mandatory quarantine. I might be corrected, but I think all of those things need to be established as urgently as possible, especially in light of the fact that we have a relatively short time frame to get the tickets booked and get ourselves onto the programs, so to speak. Thank you.
Thank you, Honorable Bryant. Honorable Singh.
No, thank you, Chair. I agree with Honorable Bryant. But in addition, these conferences, and I've attended some in different capacities, we go there sometimes as MPs and you don't get much to do. You just sit along there and there's the department and the minister saying everything. So one has also got to know, I know they mentioned the IPU, but one has also got to find out what are the side events where members of parliament from different other countries can participate in. I think that all of that will inform, inform firstly the role of MPs from different countries. And secondly, I think there is a guideline on overseas visits that we've looked at the Chief Whips Forum, and perhaps the Secretariat must get that from the Office of the Chair of Chairs. So once you've got the numbers that they would normally allow, then the committee can look at who the participants should be and whether they would comply with the COVID protocols and all the other stuff. Thank you.
Thank you, Honorable Singh. Honorable Mbata.
Thank you, Chair. I think you're right when you say it's not this portfolio committee that will choose, but it comes from the upper office, because on the 24th of June this year, there was a preparatory meeting for, it was called the Road to COP26. It was a visual international parliamentary meeting where the chairs of chairs was there, and I was there. I saw Bibi from NCOP, where they were telling us about the plans and the preparations and what they planning to do, especially to avoid the issue of COVID. But it was said that it is sitting this year in November. So I think the Office of the Chair of Chairs has all that information because he was present in that meeting. It was being done through the International Relations Department. Thank you.
All right, honorable members, perhaps it should be our decision as a committee that the administrative team should give us a report in the next portfolio committee. And we must emphasize that this is a matter of extreme agency, given the issues that have been raised by honorable members. One, issues of COVID regulations and protocols, the vaccinations, the guidelines, the roles of various members of parliament in these conferences. Can we agree that Chileka and her team should look into that and communicate with the office of Honorable Frolik and give us a comprehensive report, one on the total number of delegation from a multi-party point of view. How many members of parliament are expected to go to Glasgow, and where possible, they must also make an input on the role. And I'll, without necessarily responding directly, Honorable C. I was part of the delegation that went to Madrid in 2019 in COP25. Honorable Paulsen too. We were found wanting, you know, in the morning we must wake up and ask what are we expected to do and all of that. So I think it's very, very important that our roles are clarified so that we are not seen to be people who enjoy flying to overseas and have nothing to do there. Chileka, those are the tasks that I think the members are giving to you with the team. And on an agent basis, probably the next portfolio committee meeting should get a comprehensive report on your conversations with the office of Honorable Frolik. Is that the understanding or is that the agreement, honorable members?
No, Chairperson, sorry, I got my hand up. No. If it comes by the time of the next meeting, the conference will be over. Because we are going to recess. We are going to recess now on Friday. So I think in the next day or two, there should be a round robin, before Friday, at least a round robin amongst us. And we can talk to each other by teleconference or whatever and just exchange information. That's what I would suggest. Thank you.
Oh, okay.
Yes, so Chairperson, from my side, I was going to say the same thing. And also, if we can just include as a resolution from the committee that there is agreement in the committee that it would be preferable, that a multi-party delegation does attend. Just that, it's not simply a query; it is also, the sentiment of the committee that this would be beneficial.
All right, those are points of emphasis, Chileka and the team. One is that indeed it should be a multi-party delegation. Two, we should get feedback by no later than Friday, let's agree on Friday before we go on recess, so that we are able to prepare ourselves thoroughly. Those who will be traveling must get vaccinated, etc., etc. So you will see how you communicate, whether via WhatsApp, via our emails, and so on and so forth. Chileka, are you there?
Yes, yes.
All right. All right, that is the understanding of the committee. Colleagues will then get that report from Chileka on this particular item by no later than Friday. And if the meeting allows, we have now reached the last item, which is the adjournment. In terms of the agenda, it was supposed to be done by someone else. But because I have this borrowed power, Honorable Bryant, I take this opportunity to thank you, honorable members. Please express our gratitude also to the department, the technical team, and the administrative team here.
Thank you, Chairperson.
Thank you, Chairperson, for chairing a fantastic
Honorable
meeting.
Thank you, Chair.
Thank you very much.
Usinguthanda uphakamisa isandla noma ngasafanele aphakamisa.
Angibonanga, siyabonga nonke. I got another meeting now.
Thank you, Chair.
Thank you.
Thank you.
Chair,
Thank you.
Chair, why are you wearing orange?
Ufake ezasejele.